This conference will now be recorded.
So I'd like to welcome everybody to today's webinar. We are honoring the men and women who have served our country in the military. Today is Veterans Day, November 11th, 2020. And today's webinar topic is the top 3 new rules of the Veteran Aid and Attendance Benefit Program, what veterans need to know about long-term care planning for themselves, their spouses, and their family members. So as we get started, I want to share with everybody who's watching and listening some dangers and pitfalls to be aware of. And most consumers are not aware of these, so that's why we're starting with this part of the topic. So years ago, the Veterans Administration became aware that there were individuals as well as companies holding themselves out to the public as being able and educated enough to advise veterans about how to qualify for the various different benefit programs that the VA offers. And the reason this came to the VA's attention is that many of these individuals and organizations were actually charging veterans and or their spouses for filing applications with the Veterans Administration. And they were taking financial advantage of the veterans, and as a result, the VA put into effect a rule that requires individuals or organizations to go through an accreditation process in order to provide assurance that they truly were well versed in the rules and could properly inform and guide a veteran. So the first thing to be aware of is that if somebody needs the advice or needs the representation, they need to be accredited, and the consumer should be entitled to be shown proof of that accreditation. The second important thing that the VA did years ago was their rule says that an accredited agent cannot charge the veteran or their spouse for completing and filing an application. So that means even someone like me who's accredited by the Veterans Administration cannot charge for filing the application. The point at which an accredited agent can charge is going to be if the application was denied. And the VA issues what's called a notice of disallowance, meaning they are denying the claim for some basis. So at that point, when the accredited agent files the appeal, that's when they are entitled to be compensated for their services. So the whole reason behind these two rules is that non-accredited people were lacking the appropriate knowledge base, the experience, and as a result, veterans were not becoming approved for benefits at the earliest possible time, and the delay was causing the veteran to incur unnecessary expense. Now, one tip that I want to share with everybody is that many counties throughout the country have an organization. Here in Broward, we call it the Broward County Elderly and Veteran Services Organization. They are staffed by retired veterans who have been trained to assist a veteran or their spouse in the process of applying for veteran benefits. So many times after somebody comes to me for counseling and they are in a position where they're going to meet the financial eligibility requirements, if they need assistance, they can get that assistance to file the application through the Broward County Elderly Veteran Service. So look for a veteran service organization in your community that can help you or the veteran. The other thing to be aware of with these rules is that rules can change. And if somebody professes to be proficient, you want to make sure they actually are, because if they don't keep up as rules and laws change, then that is to the disadvantage of the veteran or the veteran's spouse. And remember, as we go through today's webinar, there is no one-size-fits-all solution for every person because we're all different. We have different needs, we're different ages, we have different ailments or diagnoses, and we have different types of assets that have to be evaluated under the rules. So the solution should be tailored to meet the needs of the veteran so that the veteran and their spouse can not only qualify, but they can maximize the resources they are eligible to keep under the federal rules. So let's proceed to understand what is new about the Aid and Attendance Program. And what is Aid and Attendance? What is it that the Veterans Administration provides to the veteran or their spouse? So the purpose of this particular program is to help the veteran or their unremarried widow or widower safe and supported in their home environment. Now, the home can mean a home that's rented, like an apartment or a condominium. It could mean a home that is actually owned by the veteran, and it can even mean that the veteran is living in an independent living facility or an assisted living facility. The key here is that wherever the veteran is living, we need that veteran to be safe. And it means that they've reached some point in their life where they need assistance and support from somebody else in order to be safe. The benefit is a financial stipend, something that the VA will pay on a regular recurring monthly basis to the veteran, as long as the veteran continues to demonstrate that they have medical needs that qualify them. Now, keep in mind that if a veteran happens to be receiving a Social Security benefit called SSI, that's the acronym for Supplemental Security Income, or if the veteran is receiving SSDI, which is Social Security Disability Insurance, then either of those benefits may end up being reduced as a result of being approved for the Aid and Attendance Program. The other thing to just keep in the back of your mind is that if sometime down the road the veteran goes into a skilled nursing facility, then that has to be reported to the Veterans Administration, and the VA is going to reduce the amount of the aid and attendance benefit. It's going to be reduced to $90 a month, and the reason behind the reduction is because at that point in time when the veteran needs round-the-clock nursing care, the Veterans Administration makes the presumption that the veteran is going to apply to the Medicaid agency for Medicaid assistance. So therefore, the veteran does not need to depend on the VA the way the veteran previously did for that financial support. Now, if the veteran, when going into a nursing home, has a spouse, not an ex-spouse, but a spouse they are still married to, who is living back in the community, and that spouse can demonstrate that he or she needs aid and attendance for themselves, then it is possible for that spouse to get benefits despite the reduction made to the veteran. So I am sharing with you on the PowerPoint slide a very helpful page on the VA website that helps to explain the eligibility requirements we are discussing today. Now, there are basic service requirements that have to be met in addition to medical requirements and financial requirements that we're going to walk through today. So for service, we have to be able to demonstrate that the veteran started their active duty before September 8th of 1980, and they served at least 90 days of active duty. Now, one of those days needs to be during a declared period of war. And if you go to the VA's website, you will see what Congress has determined to be the beginning and the ending dates for declared periods of war. The period of war that probably causes the most confusion for veterans and their families is Vietnam. The start date that was declared by Congress is very different than when most people think that the Vietnam War began. So it's important to get and locate the DD-214, which is the form number for the Veterans Honorable Discharge Papers, and it will tell you the entry date and the discharge date. So having that information is very important in order for us to first know, does the veteran meet this important service requirement? Now, there's another possible date, which is active duty starting after September 7th of 1980. And there needs to either be 24 months of service or that they completed their full period of service. Again, even under this requirement, we must demonstrate that one day was during a declared period of war. Another very important service requirement is that the veteran meet the honorable discharge requirement. If for some reason there was a dishonorable discharge, then at that point we stop. It is not allowed to go forward with showing and demonstrating the medical requirement or the financial eligibility requirements. So there must be the satisfying of the honorable discharge requirement. Next, we're going to look at the medical requirement to qualify. So we want to be able to demonstrate that the veteran requires the aid and assistance of another person. And how do we do that? Well, the VA is going to look at what are called activities of daily living. These are things such as our ability to feed ourselves, to groom, meaning to bathe or shower, to brush our teeth, wash our face, brush our hair, to be able to transfer from a bed to a chair or vice versa, to be able to toilet independently, to go to the bathroom, to be able to dress ourselves. So these are just a few examples of what are activities of daily living. If the veteran is needing assistance with some or all of the activities of daily living, then that helps to demonstrate that the veteran meets the medical requirement. Another option is to show that the veteran is bedridden, or the veteran is in a nursing home and needs skilled level care, or the veteran is blind, and this would be established through medical documentation, or that the veteran is over age 65. Now, there's two aspects to the demonstration of meeting the medical requirement. One is a veteran administration form that the primary care physician will complete. And it's very in-depth, and the doctor is asked questions about the diagnosis, the prognosis, and how is the veteran performing their activities of daily living, as well as the administration of prescriptive medication. If the veteran is in a skilled nursing facility, then in addition, there is a VA form that the director of nursing and or the medical director at the nursing facility will need to complete, and that all is part of the application process. Now, there are financial requirements that have to be satisfied as well. So along this process, if any part of the process, whether it's the service requirement, the medical requirement, or the financial eligibility requirements are not met, the veteran or their spouse is not going to be approved for the aid and attendance program. It's important that all requirements are satisfied. Now, the law made a major shift in 2018. A bill had been pending in Congress for several years that attempted to align the rules for this program with the rules under the federal Medicaid program, so that people who might apply for both programs would be able to satisfy the requirements. So in 2018, one of the things that changed was that there was a net worth limit established. Previously, there really wasn't something that was defined in black and white. Now we do. Now we know that the net worth for either an unmarried or a married veteran is $129,094. So this means all assets, whether they're in the veteran's name or they're jointly titled between the veteran and their spouse. So we haven't seen an increase yet. We'll look to see if there may be an increase in the coming year of 2021. Now, certain assets, certain resources are excluded, so they're not part of this net worth process. For example, the home is excluded. Its value does not count toward the net worth of the veteran. And if there's any debt, such as a mortgage on the home, then that also reduces the value. Generally speaking, a car is another example of an excluded resource. The VA is also going to evaluate the income of the veteran, and if the veteran is married, they are allowed to look at the veteran's spouse's income as well. So the key here is that the combined gross income not exceed what is called the maximum annual pension rate. Now this rate can change each calendar year, so be aware that the figure I've included in today's presentation only reflects the MAPR for 2020. It could increase for 2021, and we'll have to see whether Congress does a federal cost of living adjustment that would affect this program. So income is very important. Now, what if the veteran and their spouse's income exceeds the maximum annual pension rate? Does that mean that everything stops and there's no point in applying? And the answer is no, because there is a way that the income can be reduced to show a need. And how it's reduced is by demonstrating that the veteran is incurring out of pocket unreimbursable medical expenses. This means expenses that are not covered through health insurance or through a long-term care insurance policy. So I've included some examples of things that are probably incurred more frequently and tend to be larger expenses for consumers. For example, if you have to make a payment to the community where you're living, could be an independent living facility, could be an assisted living facility. So you are allowed to deduct that expense from your gross income to show the reduced income and demonstrate a need for financial support. Another big ticket item some veterans incur is for home health services through a licensed agency or perhaps through a registry. The key is to demonstrate that these unreimbursable medical expenses are being incurred on a recurring basis. Recurring meaning every month. Or perhaps the veteran is paying towards installments to pay down on a funeral plan. Or let's say the veteran pursues non-traditional medical treatments or alternative treatments. This might include acupuncture. That is permissible to deduct as well. Or maybe over-the-counter medications and drugs. So it's important that the veteran keep their receipts, they keep this information organized so it can be submitted with the application. As long as the expenses are considered to be medically necessary, the VA will allow the proper deduction. Now, a second tip that I want to share with everybody, and this was part of the change in 2018 that Congress made when it created the new law, is previously the VA did not have what Medicaid refers to as a look-back period, meaning that the VA can ask the veteran or their spouse who is applying for benefits, have you transferred or given away anything of value in the 3 years preceding the application. So before 2018, there was no look-back period. Now there is. So do not be surprised on the application that you will be asked this question, and you must answer it truthfully. You don't want to be accused of committing fraud and then losing the opportunity to become eligible for benefits. So there is a slight difference between this rule that the VA has and the Medicaid rule. So I want to bring it to your attention. The federal Medicaid law has a 5-year look back. I'm anticipating that over the next few years, the VA will end up changing its rule to be exactly the same as the Medicaid rule. But for now, the VA has a 3-year look back. So the thing to understand is if the veteran's net worth is at or below the $129,000 figure and they choose to give away assets, that will not make the veteran ineligible. It's only if the resource limit was exceeded and the veteran gave away assets in order to become eligible that the VA will apply a penalty. And what a penalty means is that it's a period of time that the veteran will be disqualified or their spouse disqualified to receive aid and attendance benefits. Now, how long that penalty will be depends upon the value of the assets that were given away. So the VA will take the value of the assets transferred, they will divide it by the MAPR, which is the maximum annual pension rate, and that will then tell the VA the period of time, meaning the years, the months, the weeks, or the days that the veteran or their spouse is ineligible. So the veteran will have to wait that period of time. When it has expired, then the veteran or their spouse can reapply for the program. And as long as the other eligibility requirements are satisfied, then the veteran or their spouse will be approved for aid and attendance. Now be aware that the VA new rule does allow the transferred assets to be returned and thereby to cure the penalty, meaning you can either reduce or completely erase the penalty period and therefore become eligible if the returned assets keeps the veteran below the resource limit. If it doesn't, then we have to find a way to help the veteran. We might suggest spending down on things that the veteran needs, such as home health services, or we might suggest paying a family member who's providing services to keep the veteran safe. So there is that opportunity to cure the transfer and erase the penalty. Now, if a transfer was made to a trust for a child that cannot take care of themselves, this happens to be one of the rare exemptions that is allowed under the new rules and does not cause a penalty to the veteran. So please keep in mind two things. The look-back period may be increased in future years. And the other thing to keep in mind is if the veteran is healthy, and so the veteran is really not in need of aid attendance, but the veteran's spouse is not well. Unfortunately, the spouse is not able to ask and qualify for aid and attendance until such time that the veteran, him or herself, is going to qualify. So if we have the veteran in a position where medically they need assistance, then we can also seek assistance, excuse me, for their spouse. So one of the things I want to bring to people's attention, because this is an area in which I think consumers are taken advantage of by people that are not accredited agents, is they are sometimes attempted to be sold annuities, which are an insurance type of product where the veteran or the consumer pays money to an insurance company in return for a commitment by that insurance company to repay the veteran their investment with a certain rate of interest. The rate of interest can either vary with the stock market or it can be a constant figure, the same percentage paid each month. Now, for both consumers that want to qualify for Medicaid or veteran benefits, the rules are different under the different programs. So you have to be very careful if an annuity is bought after the VA changed its rules, because unless the veteran can liquidate, meaning they can get their investment back, it's going to be a countable resource. So what I'm saying is it doesn't necessarily mean that the veteran is going to be able to qualify by thinking they've reduced their net worth by purchasing an annuity. This is now going to be viewed as a transfer of resources if it is purchased after October 1st of 2018. So be very careful about people or organizations that attempt to sell veterans an annuity. Similarly, if you are told to create a revocable trust, which is a legal document, and put your assets in the trust and you'll qualify for aid and attendance, that's also misinformation that you do not want to rely upon. Assets in a revocable trust are viewed as still being your assets. Why? Because the trust can be changed by you and you're in control of the trust. So therefore, the assets in the trust count. So again, be very careful if you're receiving any kind of advice like this. It means the person advising you is probably not accredited, is not properly informed, and hasn't kept up with the changes in the law or the rules. So don't make a mistake by relying on the misinformation they provide. Another pitfall to be aware of is not to confuse the VA rules with the Medicaid rules. So for example, under the Medicaid rules, more and different types of resources are considered exempt or non-countable. For example, here in Florida, under our Medicaid laws, a person applying who happens to have an IRA, which is an individual retirement account, can have that asset exempt if they're taking monthly minimum distributions. But that same rule won't work in the VA context. The IRA is a countable resource toward the net worth. Another example is that under the Medicaid rules, we have some exceptions to transferring assets that won't penalize the person applying. For example, if we have an adult child who is taking care of us, they are our caregiver, we can help to compensate them for their time and service. Or if we have a child with a disability, we can transfer assets to them and be able to qualify for Medicaid and not be penalized. Also, under the Medicaid rules, if we're married, we can shift assets out of our name to our healthy spouse and qualify for Medicaid, but we don't have that same rule yet in the VA context. So you have to be very careful, and you have to almost sometimes decide whether there are better benefits available to the veteran under the VA program rather than under the Medicaid program. Sometimes we have to pick and choose. But both programs do allow a caregiver, and the caregiver doesn't necessarily have to be related by blood or marriage, but a caregiver can be compensated. Ideally, we want to demonstrate that this caregiver is providing the same services on a regular recurring basis. And in the ideal world, we would want to document it in writing, what that caregiver is doing, how often they do it, how many hours a month, and we want to document the compensation. That way, neither agency thinks that this is just a gift. They understand that it is a contract, it's an arm's length transaction where the caregiver is being treated as any other paid caregiver might be treated. Another similarity between the VA rules and the Medicaid rules is that both programs allow people to purchase and pay for funeral arrangements and not have those funeral arrangements counted as a resource. Also, both the VA program and the Medicaid program allow a consumer to use their resources to repair and maintain and improve their home. So since the value of the home is not counted, the fact that the value is increased by the improvements is permissible use of resources. So in conclusion, I'd like to share a couple of helpful tips and suggestions, and that is you want to consult with an accredited agent. They don't have to necessarily be an attorney, but there are some advantages when you work with a qualified attorney who happens to be an accredited agent. Number two, it's important to think about and identify what your current needs are and what your future goals are. This will help identify the best planning options for you as well as for your family. If you haven't already enrolled in the Veterans Administration healthcare system, I do suggest that you do that because there may be other medical programs that will help you. So for example, you might be able to obtain homemaker services, respite care, and if you've been diagnosed with kidney failure, there is a program specifically for that that may assist you as well. And then, of course, we have to evaluate whether the Veterans Aid and Attendance Program or the Medicaid program are more beneficial so that the plan that is put in place for you is tailored to help you qualify. And then, of course, we want you to understand the impact that a plan has on other potential benefits, whether they be Social Security benefits or Medicaid assistance benefits. So hopefully you can see why it isn't a one-size-fits-all approach, but the approach really needs to be tailored to the specific veteran, and if they have a dependent, such as a spouse, that it includes the spouse's needs as well. At this time, I'd like to open it up to any questions anybody would like to ask. You're welcome to unmute your microphone or write a question in the chat box. So it seems there are no questions. I'd like to remind everybody to join me for our webinars monthly. You can go to our firm's website, www.fl-elderlaw.com. And when you go to the calendar page, you'll see the upcoming webinars listed. You can register right on the website, and you will receive an email with the link to join the webinar through GoToMeeting. If you missed a webinar or would like to share one, you can go to our events page, our resources page, and there you will see a listing of all the recorded webinars that you can register to view at your own time and convenience. And I do encourage everybody who's watching to go to the Contact Us page. You can register to receive a free document checklist to help you prepare for your consult with me, determine what documents you have in place and which ones you might still need for your plan to be truly complete. You'll also be able to receive a complimentary gift certificate for a 20% discount on your consultation. So I'd like to thank everybody who joined me today. Be safe, stay healthy, and I look forward to you joining me in the future.